Recently, Gun Owners of America had the important opportunity to testify at the confirmation hearings of Supreme Court nominee Elena Kagan. Over the course of the hearings, Kagan was asked numerous times about recent Supreme Court decisions regarding the Second Amendment, that it's an individual right and that it applies to the states. While Kagan talked a lot about precedent and settled law, she would not say if she believes the Second Amendment protects a fundamental individual right. William Olson, counsel of record for Gun Owners of America in numerous gun rights cases.
Mr. Olson.
Thank you, Senator Schumer and Senator Sessions and Senator Hatch. Our law firm represents one of the nation's leading Second Amendment groups, Gun Owners of America, and we have filed amicus briefs in Supreme Court cases such as Heller and McDonald. Despite the court's decisions in Heller and McDonald, Americans understand that the right to keep and bear arms continues to be in jeopardy. Both victories were achieved by narrow 5-4 votes, and Ms. Kagan is not a person who could be expected to defend the Second Amendment. Early in her career, Ms. Kagan evidenced visceral hostility to the people's right to keep and bear arms as a law clerk to Justice Thurgood Marshall in the Sandage case. I'm familiar with that case because, with Dan Peterson, I filed the only amicus brief supporting Mr. Sandage. I searched for my Sandage file, and here's what I found. Mr. Sandage was an African-American man who worked at a laundromat in the district. He was required to carry its cash receipts with him to his apartment over the laundromat, which necessitated him leaving the building and walking around the street briefly between the two entrances. Mr. Sandage had been robbed previously. When arrested, he was carrying a .25 caliber semi-automatic pistol to protect himself. Ms. Kagan urged Justice Marshall to deny the petition for cert for one reason: I'm not sympathetic. Supreme Court rules set forth the standards for granting cert. I'm not sympathetic is not among them. If Ms. Kagan meant that she was not sympathetic with his legal position, remember that the Sandage court had ruled that the Second Amendment was only a collective right, not an individual right. If Ms. Kagan meant she was not sympathetic with Mr. Sandage, Ms. Kagan turned her back on a man who was made into a felon for exercising his right to keep and bear arms. In 1997, in Prinsby, United States, the Supreme Court struck down the Brady Bill requirement that state and local law enforcement officers must work for the federal government, doing background checks on handgun sales. While that case was still pending, the Clinton White House was designing an end-run strategy should it lose the case, and Ms. Kagan was in the thick of it. An email reveals her role. Based on Elena's suggestions, I have sought options as to what POTUS could do by executive action. For example, could he, by executive order, prohibit a federal firearms licensee from selling a handgun without a chief law enforcement officer certification? Ms. Kagan appears to have believed that the president could circumvent Congress and act without statutory authority to impose restrictions on firearms. Ms. Kagan then worked on the presidential directive that would suspend the importation of firearms that were legal under the law that Congress had passed. When asked in these hearings by Senator Grassley on Tuesday of this week whether the Second Amendment codified a pre-existing right or whether the right to keep and bear arms was created by the Constitution, she replied, "I never really considered the question." When Senator Grassley asked whether the Second Amendment right was a fundamental right, Ms. Kagan said it was because the majority of justices in the McDonald case said so. The Kagan view of rights is that they are whatever a majority of the Supreme Court rules at a particular time in a particular case. But under that philosophy, what the court grants, the court may take away. If Ms. Kagan does not know whether our inalienable rights to defend ourselves from criminals and tyrants comes from God, as the Declaration of Independence states, or from government, she cannot be trusted to protect our God-given right to self-preservation. During these hearings, Ms. Kagan also acknowledged that Heller had precedential weight and agreed to abide by it, but refrained from providing her own personal views or whether the case was rightly decided. When asked whether the Second Amendment protected an individual right, she said, "There's no question after Heller that the Second Amendment contains such a guarantee." That's nice, but what about before Heller? Heller did not rewrite the Second Amendment. The Supreme Court decision only rejected a false notion that it protected only collective rights. Ms. Kagan's answer that she is bound by Heller provides us no assurance that as a justice she is bound by the Second Amendment as written by the framers. Thank you, Mr. Chairman.
Thank you, Mr. Olson. And now, objection.
Mr. Olson, I think it was important, the point you made, just briefly, because my time is short. The statement when she said about the right to keep and bear arms, individual right, those statements related, I think, as you correctly stated, to her statement of what the court held. It had no connection to what she might conclude. That was very similar to now Justice Sotomayor, who made the same statements and was in the minority, the 5-4 case, voting on not to uphold gun rights. Is that right?
Yes, sir. Actually, that's a characteristic displayed by some people who have a philosophy called judicial supremacism, which is to say that they respect what their fellow justices say, they respect what their predecessor justices say, but not so much what the framers said when they wrote the Constitution. And that was the danger of her view, as expressed yesterday.
Okay, many of my constituents are concerned about how judicial appointments will affect the status of the right to keep and bear arms, especially in our state of Utah. Despite what some people, including a number of my Senate colleagues, may claim, I think the vast majority of Americans are pleased with the court's ruling on both the District of Columbia versus Heller and that was in 2008, as well as McDonald versus City of Chicago earlier this week. Now, these decisions embody the obvious interpretation of the Second Amendment that the right to keep and bear arms is an individual right, a fundamental right, and a right that local, state, and federal government must at all times respect. Now, some may fear that in the future, as an activist Supreme Court may overturn, or an activist Supreme Court may overturn these landmark decisions. They were both 5-4 decisions. The more immediate concern, however, may be that the lower courts might apply the Heller and McDonald decisions to so narrowly that they have little or no practical effect. And that is the present concern. Courts could claim to be applying these precedents while strangling them and undermining the rights of law-abiding gun owners. Now, how legitimate is this concern? And given what you know about General Kagan's record in this area, is this something we should be thinking about as we consider whether to vote for or against her in her confirmation?
Yes, Senator. If you read the Heller case carefully, the opinion of even the dissenting judges, Justice Breyer and others, accepted the fact that the Second Amendment protected an individual right, but then went on to say it's all a matter of the scope of the right. You haven't even gotten that commitment from Solicitor General Kagan. In other words, if she were to go on to the court with what we know about her now, she could be the most anti-gun justice on that court.